33 amendments to the Constitution of the United States has been proposed by the United States Congress and sent to the states for ratification since the Constitution was put into operation on 4th March 1789. Hello friends, welcome back to the channel. Before moving ahead, like, share, subscribe and don't forget to press the bell icon. 27 of those having been ratified by the requisite number of states are part of the Constitution. The first 10th Amendment was adopted and ratified simultaneously and are known collectively as a Bill of Rights. The 13th, 14th, and 15th Amendment are collectively known as the Reconstruction Amendment. 6 amendments adopted by Congress and sent to the state have not been ratified by the required number of states. 4 of those amendments are still pending, 1 is closed and has failed by its own term, and 1 is closed and has failed by the term of the resolution proposing it. Article 5 of the United States Constitution details the two-step process for amending the nation's plan of government. Amendment must be properly proposed and ratified before becoming operative. This process was designed to strike a balance between the excesses of constant change and inflexibility. An amendment may be proposed and sent to the state for ratification by either United States Congress whenever a two-thirds majority in both the Senate and the House of Representatives deem it necessary, or a national convention called by Congress for their purpose on the application of the legislature of two-thirds of the state. 34 since 1959. This option has never been used. To become part of the Constitution, an amendment must be ratified by the 3/4 of the state. 38 since 1959 by either as determined by Congress, the legislatures of 3/4 of the state, or the state ratifying convention in 3/4 of the state. The only amendment to be ratified through this method thus far is the 21st Amendment in 1933. The amendment is also the only one that explicitly repeals as earlier one the 18th Amendment ratified in 1919 establishing the prohibition of alcohol. Congress has also enacted statutes governing the constitutional amendment process. When a constitutional amendment is sent to the state for ratification, the Archivist of the United States is charged with responsibility for administrating the ratification process under the provision of 1 United States Constitution. Then, upon being properly ratified, the Archivist issues a certificate proclaiming that an amendment has become an operative part of the Constitution. Since the early 20th century, Congress has on several occasions stipulated that an amendment must be ratified by the required number of states within 7 years from the date of its submission to the state in order to become part of the Constitution. Congress's authority to set a ratification deadline was affirmed in 1939 by the Supreme Court of the United States in Coleman v. Miller. In the absence of the deadline, an amendment can be pending indefinitely and ratified long after being proposed to the state.